what we're going to do tonight is we're going to go over the quizzes in chapters 5, 6, and 20. And we're going to put that behind us. And then we're going to get into the rest of chapter 7, which is a really important chapter, which is agency. And hopefully we're going to get to the end. There's a couple of videos. They're pretty much the same video, but it kind of it's the Real Estate Commission's explanation of how we work with buyers and how we work with sellers. And when we talk about that, it's the real estate disclosure form. Now, obviously, through the difference of either buying and selling, that's going to be a different practice. But we're going to introduce something tonight called an oral buyer's agency. And without getting into too much right now, that's what the difference is. We can never do anything orally as a client for a seller. A listing agreement is a listing agreement. That has to be done before I can do anything. But when we start talking about the buyer's agency, we literally can go until we decide to present a contract with an oral representation agreement. So we don't have anything in writing at that point. So there's a couple of ways to do it, and there are some rules to that. So it's not a matter of just being able to just say, all right, well, don't worry about anything. So we'll get into that, and that's a little more detail. We're also going to talk about misrepresentations tonight. We're going to talk about stigmatized properties. Talk about a few things, some of the different types of agency relationships that we're going to have. And we'll introduce dual agency and designated agency before the end of this chapter. So hopefully we'll get in there. Now, remember what I told you all. I think there are enough of you in here now. Do not forget that this booklet is required from page 106. All right. That is the license law and rules comments. Start at page 106. I just put it in your chat box. All right. You got to read it. You're on your own if you don't. Okay. I can't explain. I'm not going to babysit you, but you're on your own if you don't. And if you don't read it and you don't understand what's in there, you got no chance. You got no chance. So put yourself in position, right? So it's from page 106 through 126. Now we're going to spend a good deal of time next week getting into, once we get through chapter 7 and chapter 8, which we'll finish chapter 7 tonight. I don't know if we'll get into chapter 8, but once we're done with chapter 8 on Tuesday, we're going directly into the Appendix A, which is starting at page 106 in that page 106 to the end, which is, I believe, page 127. All right. So it's right to the end. If I was studying, I'd print out those last 20 pages. And again, I like to print things out, but if you can do it on your own without printing it out, that's fine. But I would be highlighting, I'd be writing notes, anything that doesn't, make sure I put it in my head one way or the other, whatever it takes to get it in your head. All right, because those are all the license law. That's the license law, what I'm telling you. So that's going to be a huge amount of your state portion of your exam. Okay, a huge amount. So there's the link. Don't lose it. It's in your Dropbox. All right, it's not only in your Dropbox under the most important docs that you're going to use, it's also in the section that says, if Sam were studying, I'm giving it to you here. It's in your original email. So you got about 20 copies of it. Now all you got to do is open it. All right. All you got to do is get in it. All right. So make sure that is mission critical for this whole class. You got to do that. All right. So study it, spend some time in there. That's going to be a huge amount of what you're going to do over the weekend. Okay. That and celebrate the new year. Y'all did your Christmas celebrations, though. New Year's is just another day. So you're all right. Go out and have a good time and then come out, sleep it off, get in your book. Got work to do, right? We all do. All right. So this is, we're going to finish up on liens and encumbrances in chapter 5. And then we're going to go into chapter 6, which is property, which is public and private deed restrictions. Okay. So the first question here, in North Carolina, the statutory period for adverse possession, right? Remember somebody taking your property and they want property for it and you haven't been told, it has to be open, notorious, right? Can't be hiding, okay? The statutory period for adverse possession without the color of title is an uninterrupted period of how many years when trying to acquire privately owned property? And it is 20 years. So let's say you came across an old abandoned farmhouse and you went in there. You decided to stay. There was nobody there. Nobody chased you out, right? You could stay there for 20 years as long as you didn't hide when somebody came in there and as long as nobody told you to leave, okay? And if it's uninterrupted for 20 years, you can lay claim to it. You can go to court and say, I want it. Now, what is the color of title? The color of title, this is without the color of title. The color of title, if you remember, is if you had an actual closing. You went and you had an actual closing and you got the deed and everything else. And then somewhere around 8 years later, somebody knocks on your front door and says, you know, there was a mistake when you bought this house. You weren't supposed to be the owner. I still owned it. I never gave it up. So you had what was called the color of title. You had it. You thought you owned it. You did it legitimately. Everything was up and up. So that was a 7 years. That you have to have the color of title for 7 years. You were under the assumption that you owned it from day one. Okay, so that's the color of title. Mm-hmm. So color of title, 7 years. Adverse possession is 20 years. Okay, just remember that. Okay, number 2. Title to real estate may be transferred during a person's lifetime by which of the following means? Okay, well, escheat is when the government takes your house, takes your property when they can't find heirs. Okay, descent is when you die, so it's not while you're during your lifetime. And the device is your will, so that's not during your lifetime. You can't transfer properties while you're still alive. Alienation, though. Alienation is you're going to push it away. You're going to sell it. So that is during the person's lifetime. Now, be very, very careful of that question, right? That's the kind of question. You can get rid of your property by all of these things, right? But it says one in your lifetime, which means you're still alive, right? So be very, very careful of that kind of question. In this particular case, it's alienation. You can sell your house. The rest of these would be all because you are not alive. All right. Number 3, what type of deed might an owner of real estate use to voluntarily transfer a right, a title, or an interest in real estate? Okay, a right, a title, or interest in real estate. And it is a warranty deed. That's the one we want. Remember the 4 types we were concerned about, but you have all of these others too, right? Sheriff's deed could be a tax deed. Foreclosure deed could be a, well, just what it is, it's a foreclosure deed. Technically, it is more called a trustee's deed. That's who's going to get a deed of trust, and they're going to sell it when we talk about Chapter 9. We're going to talk about mortgages and things of that nature and deeds of trust. But a warranty deed, we have general warranty deed, which is the best one. We get all the covenants, right? And that goes back all 30 years, right? They're going to give it to you and they're going to protect you with it. A special warranty deed, which is they're going to go back for as long as the person who's selling it says that they own it, and they're going to protect you for as long as they've owned it, right? Then we have a bargain and sale deed. Bargain and sale deed is going to be a deed where they say they own it, but they're not giving you any warranties. They say you own it, here you go, you can have it, whatever happens, happens. And then the quitclaim deed, which is, I'm not even going to say I own it, but if I had any claim to it, I'm giving up any claim I might have had. And that's really the quitclaim deed, which is, and we'll see that, I think, in another question or two. So that's going to be where you are going to, you'll see that. And they clear up a lot of clouds on the titles, things of that nature, using a quitclaim deed. Simple divorce petitions where they're going to give a house to one spouse or the other, they'll use that. Just kind of separate everything out. Okay. So the warranty deed is the one that we want. That's the best one that we can have. The general warranty deed is one we want. Number 4, a man owned property as a tenant in common with his 2 best friends. Years later, the man was adjudged legally incompetent and moved into a nursing home. During his stay at the nursing home, the man wrote a will leaving his entire estate to the nursing assistant assigned to his care. The man was survived by 3 children when he died. After his death, his real estate interest passed on to C, his children, by the law of intestate succession. His will was null and void. He could not get into a will. Why? Because if he's under guardianship, he can't sign a legal document. He can't sign any of that. Now, if his guardian signed it, right? His guardian signed it, then it would have been a legal document because the state put the guardian in charge of all of those things that that person could do. But otherwise, it's just it's a null and void document, and the kids would just get it because intestate succession means that the next person is going to get it. They're going to look for the next person in line, okay? Regardless of if there's a will or not. And in this particular case, the will is invalid. Number 5, which of the following is not a means of title transfer by involuntary alienation? Involuntary alienation. Eminent domain means what? They're going to, the government has the right to take private property for the public good, right? That is the law. That's the law. That's not the act. What's the act called? Anybody remember what the act of taking the property is called? Condemnation. There you go. There you go. Right? So the law says we have eminent domain. We can take the property. Condemnation is the act, and we have to pay what? Just compensation, whatever that is, right? We have to figure out what the value of that property is, and you can do that, okay? So escheat means they haven't been able to find somebody to take it. Foreclosure, obviously you didn't pay the bill, they're going to sell it out for under you, so those are all involuntary. By will, though, is voluntary, right? You're going to give it to whomever you want to through your will, right? As long as there's not any kind of survivorship in your title. Number 6, which of the following best describes the covenant of quiet enjoyment? Quiet enjoyment basically says not that your neighbors aren't going to harass you or bother you or make a lot of noise. Quiet enjoyment means that nobody's going to come at you and try to take your house with a superior title. Okay, so that's the right of quiet enjoyment. So it's D. The grantor ensures that the title will be good against the title claims of third parties. Okay, so nobody's going to try to take this out with a superior claim to this deed, to this title. All right. Number 7. A purchaser went to the registry of deeds to check the public records. She found that the seller was the grantee in the last recorded deed and that no mortgage was ever on record against the property. Therefore, the purchaser may assume which of the following. And the only thing you can assume on that is that the seller probably didn't mortgage the property, right? There's no other way there's nothing else you can assume there, right? You can't tell by looking at the register of deeds whether the taxes have been paid, all right? You can't tell whether the seller has good title or not. He's got it. It was already paid. It was recorded, right? And probably no one else is occupying the property. Doesn't matter. The only thing you can confer out of this is that they didn't have a mortgage, all right? Number 8. The person who examines the chain of title and prepares an opinion of title for a parcel of real estate, A, writes a brief history of the record of ownership of the property. It goes from Wayne to Sam to Reagan to Anastasia to Ennis and all the years that they've owned it and how it is. That's the chain, right? So now if we were going to do an abstract, it would go from Wayne to Sam, and these are all the documents that were signed on that particular day. Then it would go from Sam to Reagan, and these are all of the documents that were signed. There's a little more detail in the abstract than there is in the chain. We're just listing the chain going through there. Instruments affecting real estate are recorded in the public records of the county where the property is located. Because number 1, recording gives constructive notice to the world of the rights and interests in a particular parcel of real estate. That is true. This is a public when you do this, this is constructive notice. It lets the world know, right? I showed you when we did the counties how to find it. It's all public information, right? Well, we don't just get that because we get a taxes. Your taxes are recorded. That's why it becomes public. And second, the instrument must be recorded to comply with the terms of the county recording laws. You don't have to record it at all, right? You don't have to, but must. So number 1 is A, all right? A is 1 only. Number 10, the chain of title refers to A, D, a succession of conveyances from some starting point whereby the present owner derives the title. This is what I was talking about as we were just going through the ones, right? This says that's the chain of title, one person to the next, to the next, to the next. Number 11, a title insurance policy, which with standard coverage generally covers all of the following, except, all right, the right, and the answer is C, the rights to the parties in possession, okay? The rights to the party in possession is the seller, so we're not really going to cover that. Forged documents, incorrect marital statements, incompetent grantors. Remember what I was just saying about all these people coming back and trying to make that's why your title search, that's what your title insurance policy will cover, right? But once you take possession, once you are the buyer and you take possession of that property, that title insurance looks backwards to prior when you got it. It is not by any means looking forward. So it protects the history of the property. That's what title insurance does. Make sure that you are the rightful owner. And if not, it will help you defend against some of these other things. Number 12, condemnation. All right, we talked about this earlier, is the process by which eminent domain is exercised. Eminent domain gives us the right to take private property for personal use, personal property for private use. I'll try that again. This is 0 for 3, right? Take private property for public use. That's what eminent domain does. Sorry about that. And we use the process of condemnation to take that. All right. Number 13, which of the following is not a necessary condition of eminent domain? All right. And the answer is B, property is to be given to an owner of a quasi-public corporation. It's got to be for the public use, right? It's got to be for the public use, not a public quasi-public corporation and not given to the owner. It has to be for the public use. Roadways, different ways to expansions of roadways, expansions of maybe you need water rights, maybe you need some other stuff, but it can't be to a corporation, right? It has to be for the public good. Number 14, which of the following real estate documents is least likely to be recorded? All right, remember this, okay? This is key. Leases of less than 3 years do not have to be A, in writing, and B, recorded, okay? Leases of less than 3 years can be oral, and they do not need to be recorded, okay? 3 years or more, they must be both of those, but up to 3 years, they do not have to be. You're probably, just because they can doesn't mean they should. You're probably, even if you sign a 1 year lease, you're going to sign a written agreement. But the point is that a month to month does not have to be written or or recorded. Okay. All these other contracts probably going to get there. Number 15. Which of the following should be discoverable in a search of the public records? Okay. And these are easements on the property because why? Easements are what? Appurtenant, right? They run with the land. And the only reason they're appurtenant is because we have to what? We have to record them, right? So we have to record easements so that the next purchaser knows there's an easement on that property. Whether it's an easement in gross for utility lines or what not have you, or it's an easement appurtenant by necessity because the neighbor's got to use a roadway, what have you, okay? Those things would be discoverable in a search for public records. Number 16. In North Carolina, the statutory period of possession required to acquire title of privately owned property by adverse possession with color of title is how many years? This is that 7-year rule we talked about earlier, right? I went to court, I went to a settlement, we signed the documents, everything was perfect. I moved in, I held this property for 7.5 years, and all of a sudden somebody under a superior title decides they want their house back. It wasn't mine to begin with. Well, for all my paperwork and all my documents and everything I went through, I was under the impression that I had ownership. That is the color of title, okay? And you have to have it for 7 years. Number 17, which type of deed merely implies but does not specifically warrant that the grantor holds good title to the property, okay? And that is a bargain and sale deed, right? I got ownership, but I'm not warranting anything. Okay, it's yours. All right, I got ownership. Number 18, the NCBA/NCAR 2T offer to purchase and contract form. This is our offer to purchase, and we're going to get into that. This is our contract. NCBA stands for the North Carolina Bar Association. NCAR stands for the North Carolina Association of Realtors. 2T is the form number, and it is going to be the offer to purchase. All right, indicates that the seller will deliver which deed to the buyer. Inside the boilerplate language of that contract says that a general warranty deed will be delivered. If you're getting some other type of general deed, you're going to have to do an amendment and say, we're going to deliver a special warranty deed or a quitclaim deed or what have you, all right, inside that purchase. All right, a little math to finish up. This is easy math, right? When a property is sold for $75,000, the excise tax would be what? I know the answer is there, but do you know how to do it? You're going to take that. You're going to take that $75,000. Remember, it's $1 per 500 of sales price, or any part thereof. So we always round up to the next dollar. There are no decimal points here. So 75,000 divided by 500, going to be $150. Who pays? The seller pays, right? Exactly. And it's always on the full purchase price. So whatever discounting goes on after that, whatever the full purchase price is what this is calculated on. Okay. All right, number 20. A seller sold his property for $185,900 and let the buyer assume his loan balance of $125,000. How much excise tax will the seller pay at closing? All right, remember I just said that it's on the full sales price, so we don't care how much the loan balance was or the assumption. All right, we go back to that $185,900. Now, if we divide 500 in there, if we divide it by 500, it's going to give us C. But notice C is not the right answer. Why? Because we have to round up to the next whole dollar, right? We have to round up. So the excise tax will be $372 because we have a decimal. There is no decimal. All right, we round it up, 372, and it's payable by the seller. So that's what happens. You got to round up. Now, this is when we're start talking about what? Zoning, public regulations, private regulations, right? Land use controls. So that's what Unit 6 was all about. Okay. So let's go through this. All right. So number 1, a provision in a subdivision declaration used as a means of forcing the grantee to live up to the terms under which the grantee holds title to the land is a protective covenant. This is your CCRs, all right? Your deeds and covenants and restrictions in your local HOAs. Those are protective covenants, right? You have to do this in order to stay here. In order to live here, you have to comply by these rules. Number 2, tests commonly applied in determining the validity of zoning ordinances require all of the following except D, all right? So you need to have the power be exercised in a reasonable manner, okay? The ordinances be free from discrimination. They can't discriminate if they're going to make a zoning ordinance, and that the ordinance apply to all property in a similar manner. So if they're going to change an area from a commercial area to a residential area, they can't do it arbitrarily. They have to be able to let everybody know that. They can't use this in against anybody, all right? So they can't force you to close or whatever. Because then if it's a viable business, it would be what, a legal non-conforming use if we changed it? So we'd allow them to stay in there, okay? So those are zoning ordinances. D is the incorrect answer, that the ordinance causes a loss of property value for the public good. There's no such thing. There's no such thing. Doesn't work that way. Number 3, public land use controls include all of the following except, now these are public. So B is a restrictive covenant. That is a private control. Restrictive covenants are in your HOAs, right? That's a private control. Subdivision regulations, environmental protection laws, master plan specifications, those are public. Those are public. Those are done by your county zoning or your city zoning, right? Number 4, zoning powers are conferred on municipal governments by, number 1, the state enabling acts. That's it. Eminent domain, we talked about, that's how you take property, but that's not how zoning powers are conferred, all right? The enabling acts are how the municipality gets his power to govern, all right? Gives them police power. Number 5, zoning laws are generally enforced by B, non-issuance of building permits to properties that do not conform to zoning. If we are in a zone, a residential zone that wants 20,000 square feet of property, which is roughly a half a builder's acre, and that's the zoning, and we try to put a house on 10,000 square feet, are they going to give me a building permit? No, they're going to tell me, no, you can't build there. Okay, so that's how they do it. It's really, they're not going to give me a building permit. All right, that's how they're going to do it. They're going to control it. Okay, they're going to control it. All right, number 6. Zoning boards of adjustment are established to hear complaints about B, the effects of a zoning ordinance, right? You have to go, usually they have 3 hearings. Usually you can go and state your cases, do all of those things where you can complain or not, or say it's a good thing or say it's not a good thing, or maybe you can bring out some things that might be affected, right? Unintended consequences of making this change. That's why they usually have 3 readings of those zoning ordinances. And they have a public comment period. So they would expect that if you had a comment, you would make it, right? Number 7, zoning allows regulation of all of the following except number of buildings, yes. Size of buildings, yes. Building occupancy, yes. Building ownership, they can't say who can own the building, right? They can't do that. That's a violation of fair housing. So they cannot allow, I mean, they can do everything else except regulate who owns it. Number 8, the purpose of a building permit is to, number 1, maintain municipal control over the volume of the building. No, that's not true. Okay, they want to maintain, provide evidence of compliance with municipal building codes. That is a building permit. So it's B, it's 2 only. Remember, building permits is both safety, right, and zoning in those particular cases. We're going to need a building permit. A local man, number 9, a local man owns a vacant lot in a residential building, a residential neighborhood. His friends in the city government managed to change the zoning on his lot to commercial so he can increase his profits on the property. This type of zoning is called spot zoning, all right? So a local man owns a vacant lot in the residential neighborhood. Now it's vacant, right? His friends in the city government managed to change the zoning on his lot to commercial so he can increase his profits on the property. This type of zoning is called a spot zoning. Now, if you put down that this would be an illegal use, I could understand how you answered that, okay? But he didn't do anything illegal. It was a vacant lot. And he went in and applied. If you go in to apply to the city government and say, okay, I want to put a grocery store here and I have a need, whether they're my friends or not, if they're going to pass me through, then, obviously they're my friends. But let's say I already had, it could, they could, I don't want to get too much into the gray area here, but I can understand if you answered this as an illegal use, right? It just doesn't, this question stinks. Truthfully, it's a little ambiguous. Tyler, right? This question's a little ambiguous here. So, yeah, an illegal use of his friend's power. I agree with you, but it's not technically. It doesn't smell good, but it's not. Number 10, the grantor of a deed may place effective restrictions on the right to sell the land. No, can't put restrictions on the right to sell the land. He can put restrictions on the use of the land, though, right? Where you have deed restrictions, you can't, you can't have horses on the land. You can't have, maybe I have a condition subsequent or a fee simple determinable, right? Use of the land, I can do that. I can't do it on the right to sell the land because I'm giving you a fee simple. You can sell it. Number 11, a new zoning code is enacted. A building that is permitted to continue in its current use, even though that use does not conform to the new zoning, is an example of a legal non-conforming use. Remember our Circle K on the corner example we talked about, right? Everything around it became residential, but they were still pretty viable. They can stay and they're going to give them a legal non-conforming use. They don't conform with the rest of the area. Number 12, to determine whether a location can be put to future use as a retail store, one would examine the zoning codes, right? The zoning codes. That's what would be necessary. How big is this? A commercial area? How big of a store can I put in there? What's the rules? Otherwise, I can't do it. 13, a list of deed restrictions probably would not include allowable ethnic origins of purchasers. It must not, not even probably would not, all right? That is a fair housing violation, but it would have the types of buildings that could be constructed, the minimum size of the buildings, the activities that are not to be conducted at this site, could have all of those, all right? But it cannot get into the people. Now remember, we're going to talk a little bit about when we get into chapter 7 in a very short period of time. Understand this. If you talk about the house and the property and the neighborhood effects on the houses, you're going to be okay. If you start talking about the people, you are not going to be okay, right? You need to leave the people out. It does not matter, okay? It doesn't matter. And when we start talking about stigmatized properties, we'll talk more about it. But if you're making, if you're describing, talk about the property, house, beautiful house, nice architecture. Talk how it's built. Talk, access to it. What kind of rooms has it got? Well, things you can, how much property do you have? All of those things. You can talk about the house all you want. Don't, just stay away from talking about the people. Right? Because nobody cares. I take that back. Nobody should care. Right? Nobody should care. And that's where you get yourself into a problem. When we talk about stigmatized properties, right? Well, we're going to see that. What about, I'll throw it out here right now while we're doing this, was just for an answer. Now, for those folks who have taken this class before, please don't answer, but let somebody else answer it. If a sex offender moved in next door to this house, and I have a buyer, do I have to let the buyer know that a sex offender moved in next door? No, 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 no. No, don't. It's not a material fact on this property. So deed restrictions can be enforced by a court injunction, by court injunctions. Okay. Usually you have to go to court. If you're dealing with deeds, you got to go to court. Number 15, a homeowner wishes to install a hot tub in her backyard. What if they ask you? That's a really good question, Wayne. And the reason that I said that I don't check the sex offender registries is because if they ask me directly, I cannot lie. So what I can say is, it's not information that I distribute or information that I keep up on or anything else like that. Here's where I can send you. I can send you to the website. Here's the website that you can go check and find out, or go to the police station and they can give you the most accurate information. But in no case can you lie if you know. But if you say something, you got to be accurate, right? Because if you say something and it's inaccurate, who's going to be responsible? Who's the adult in the room? Who should know better? Right? So you have to be careful. So that's why there's ethical dilemmas that come up here, and that's a tricky situation. But don't even check the sex offender registry. Don't even check. Stay away from it. But don't disclose it. Right? If you don't know, it can't hurt you. You can actually say, I don't know. And then, but you have to tell them where to go. Look, here's the website. You can go check that out, or go to the police station. They can get you the most accurate information if that's important to you. And then, then they can get the most accurate information. The buyer's got to do some homework. You're going to do a lot of work for them, but they got to do some, right? They got to do some. So, yeah, that's a negligent misrepresentation at that point. If you were wrong, almost willful. If you have any question in your mind, but yes, negligent because you didn't pay attention to it or you gave wrong information. If you didn't check it and gave wrong information. If you checked it and you intentionally gave wrong information, we're going to talk about that tonight. That's willful. That's different. That's fraud. Right? That's fraud. All right, let's finish these last few questions and then we can move on here. And we'll go, after we finish this chapter, we'll go for a break and then we're going to move back into chapter 7 and get this stuff done. All right, we're going to skip over chapter 20. We'll catch up on it later. Number 15, a homeowner wishes to install a hot tub in her backyard. It'll be used to treat a medical condition. In order to prevent neighborhood children from accidentally falling into the hot tub, the owner wishes to build a 6-foot fence, but city regulations limit the fences to 4 feet. To have a 6-foot fence, the owner must obtain a variance. That's where you get your variance, right? You need it for a medical condition. You need to get this 6-foot fence up. Only allows 4 feet. You can go and get a variance to put up a 6-footer because you have a legitimate reason, all right? You have a hardship. Number 16, a residential neighborhood in Central City consists of homes built in the late 1800s. The neighborhood is subject to special zoning that prohibits property owners from tearing down a current home and replacing it with a modern home. This type of zoning is called our historic preservation zoning, right? Built in the early and late 1800s, we want those houses to stay. We want them fixed. You can't tear them down because we are in this historic preservation zoning. Number 17, a drawing showing the sizes and location of the streets, utility easements, and lots in a subdivision is called a plat map. This is what we're going to submit, right? The preliminary plat when we draw it up so that we can get final approval. Number 18, a property report required by the Interstate Land Sales Full Disclosure Act would not need to include the original purchase price paid by the developer. It doesn't matter. Maybe he was willed to it. It was willed to him. He got it for free. It doesn't matter. But it has to have the soil conditions that affect the foundations, the number of homes currently occupied, and the existence of any liens on the properties. Okay? The original purchase price does not matter. Number 19, when other property owners in an established subdivision wish to remedy a violation of a restrictive covenant by a neighbor, They should, D, hire an attorney and sue the offender. Okay. They're going to hire the attorney and sue the offender. And then you're going to have to either pay your fine or whatever cease and desist they come up with. Number 20, due to the strange shape of a lot, present zoning restrictions about parking space requirements will cause an undue hardship for the owner's planned use of the property as an office building. If there are no other reasonable uses for the property, the owner may be allowed to proceed with his plans under a variance. Okay, under a variance. No other uses for this land, they need this parking spaces. They're going to use it for that. Number 21, a gas station operated at the end of town, edge of town for 20 years, pursuant to new comprehensive plan. The city rezones the land as residential. Which statement reflects the most likely outcome? The answer is D. It is going to continue to operate as long as the building is not enlarged or the use is changed or anything else. It would be a legal non-conforming use. Number 22, which of the following statements is or are true about the subdivision regulations? Number 1, a subdivision consists of at least 5 parcels of land for the purpose of sale or development now or in the future. Remember this, you only need 2 parcels of land. A subdivision is 2, not 5, all right? So in this case, 1 is not the right answer. You need 2. And number 2, a broker can negotiate a sales contract on lots in a new subdivision only after the final subdivision plat has been recorded. We can negotiate a sales contract, we just can't close on it. Okay, we can't close on it until that final subdivision plat has been recorded. All right, so neither 1 nor 2 are correct. Number 23, which statement is false regarding on-site septic permits? All right, and the answer is D. The permit will describe maximum occupancy as 3 persons permitted per bedroom. 2 persons per bedroom, or as they say in the books, 2 heartbeats per bedroom. Doesn't have to be 2 adults or 2 children or anything else like that. All right, it doesn't define the sexes. It just says 2 heartbeats per person per bedroom. 24, the type of residential subdivision zoning that would maximize open space would be a cluster zone. That's your cul-de-sac, clustering all the houses, leaving some open space. I know that we're getting near the end here. There we go. Number 25, which of the following statements about subdivision street disclosure in North Carolina is not true? Regarding land use, real estate brokers are responsible only for determining and disclosing whether subdivision streets are privately or publicly maintained in new subdivision. Not true, okay? So A is true, a subdivision developer must disclose whether the streets in the new subdivision are intended for public or private use. B is true, buyers of a new subdivision lot must receive and sign a written disclosure of the street status. And D, a subdivision streets built to the North Carolina Department of Transportation standards for public road maintenance are not automatically adopted for state maintenance. They have to take them. They have to accept them. You can give them to, you can try to get the states to take them, take permission of them, but they don't have to. They don't have to. In that case, they are private roads and they're maintained privately. All right. All right. And it's not the real estate broker's job. It is the real estate broker's job to get that information to the purchasers. All right, last 2. Which of the following statements is false about a broker's primary responsibility regarding the land use? All right, so let's do the true ones. They're more helpful. A broker, A, must avoid any representation about a property zoning without verifying the property zoning. And if appropriate, flood hazard area maps and any restrictive covenants affecting the property. You need to know where FEMA's stuff is too. You need to know what's in a flood zone and what's not. Best thing to do is call your insurance, call an insurance person. They'll help you. They know the flood maps better than anybody. All right. Letter B is a broker is expected to be able to recognize red flag situations regarding land issues and advise the parties involved of a potential problem. If something doesn't feel right, it's not right. Right? Letter D, Brokers expected to be able to recognize patent signs of flooding on a property or when a property's location may make it susceptible to flooding. You should be able to look around. It's going to be your responsibility to walk around and look at it, all right? So you don't have to know all the protective covenants affecting a community, but you should be able to look it up. You should be able to look it up. Last one, straight piping. Is C, refers to wastewater discharged directly into the yard or into a nearby creek or stream rather than into any approved treatment system. This is illegal, this is disgusting, and you should turn somebody in for this, all right? So you need to have either city water and city sewer, or you need to have on-site septic. You cannot discharge gray water into the river, creek, backyard, anything like that, all right? Not allowed.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.